Hi friend, welcome to the Company Law Adjudication and Appeal series. Today we are discussing Bengaluru ROC Adjudication Order for the violation of Section 118 of the Companies Act, that is the minutes of the proceeding of the general meeting, meeting of the board of directors and other meeting and resolution passed by postal ballot in the matter of the Syscon Instruments Private Limited. Let's see the facts of the case. Company name is the Syscon Instruments Private Limited, having registered office in Karnataka as per the MCA record, and as per subsection 1 of section 118 says that every company shall cause minutes of the proceedings of the every general meeting, class of the shareholder or creditor, or every resolution passed by postal ballot, and every board meeting or every committee meeting to be prepared and signed in prescribed manner and kept within 30 days of the conclusion of every such meeting concerned of passing of resolution of postal ballots in books kept for that purpose with their pages consecutively numbered. And further subsection 2 says that minutes of the each meeting shall contain a fair and correct summary of the proceedings thereat. And subsection 3 said that all appointment made at any of the meetings aforesaid shall be included in the minutes of meeting. And subsection 5 says that there shall not be included in the minutes any matter which in the opinion of the chairperson. There is the mistake in the typo mistake in the order, that is which is the option, not option. This is the opinion of the chairman of the meeting. And subsection 6, according to subsection 6 of this section, stipulate that that the chairperson shall exercise absolute discretion in regard to the inclusion or non-inclusion of any matter in the minutes on the ground as specified in section 118 subsection 5. This is the ground referred that is or could reasonably be regarded as defamatory of any person or irrelevant or immaterial to the proceeding or detrimental to the interest of the company, that is the grounds. And subsection 11 says that if any default is made in the complying with the above stated provision, the company shall be liable to a penalty of the 25,000 rupees, and every officer of the company shall be default, which shall be liable to a penalty of the 5,000 rupees. So here subsection 11 provides penalty provision, and penalty is given here is the 25,000 rupees, and officer in default, that is at 5,000 rupees. And if any person is found to guilty of tampering the minutes of the proceeding, he shall be punishable with imprisonment for a term which may extend to 2 years, or and with fine which shall not be less than 25,000 rupees but which may extend to 1 lakh rupees. So these are penalty provision, and in this case company filed its adjudication application on 15th March 2021 to adjudicate the error committed in the minutes of the board meeting. Due to the COVID-19 pandemic, hearing was conducted on 24th August 2021 through virtual conference, video conferencing, but due to technical issue, hearing was adjourned. Again on 22nd November 2021, hearing was held, but it was noticed that affidavit were not submitted by all the directors who were officer in default, and hence the same was adjourned, directing the representative to submit the affidavit in respect of all the directors. The company submitted the affidavit in respect of the other director. Thereafter on 24th June 2022, the matter was heard. Authorized representative appear on behalf of the company and its director and place is a submission before the adjudicating officer. And authorized representative submitted that in respect of the violation of the provision of section 118, there was no delay or non-compliance. There was inadvertent error in reporting the date of the resignation of the director, one of director. Instead of the 20th August 2018, the date was mentioned inadvertently 1st January 2019. It is stated that director which resigned on the 8th August 2018, board took note of his resignation on 20th August 2018. However, as his dean was not KYC compliant, the DIR 12 could not be filed. The same could be filed only on 11th January 2019. The board took note of the resignation again on 1st January 2019 along with the appointment of another director. And as per the petition, due to non-compliance of the DIR KYC, the form could not be uploaded and finally could be uploaded only on 11th January 2019, informing resignation of the director. Difficulty was removed by the MCA system effective from January 2019, and immediately thereafter the company completed the filing of form DIR 12 on 11th January 2019. From the petition and explained by the representative, there is an error committed in the minutes of the board meeting at relevant period, and it is seen that the balance in profit and loss account of the company as on at 31st March 2021 paid up capital is 3.99 crore and turnover is 29.35 crore. This is company is not a small company for the imposing lesser penalty under section 446B of the Companies Act. Accordingly, maximum penalty imposed under subsection 11 of section 118. Here ROC imposed penalty on the company, that is 50,000, and on officer in default, that is 10,000 each on the officer in default. This is a penalty, that is a penalty 25,000, that is default of the two subsection of the section 118. And ROC direct that they shall pay the penalty amount from their own sources through MCA portal within 60 days from the date of the receipt of the order, and also file INC 28 attaching copy of the payment challan along with the adjudication order. In case prefer appeal against this order, then file appeal to the regional director having jurisdiction in the matter, and appeal shall be filed within the 60 days from the date of the date on which the copy of the order made by the executing officer received by the aggrieved person, and shall in prescribed form, manner accompanied by fees as may be prescribed. And in case of the default in failure to pay the penalty, then subsection 8 of section 454 attacked. Thank you so much for watching this order.